Turn to our final case for today, which is Rich versus Fox News. Just 1 second. Okay, ready to go?
Ready to go.
Go right ahead.
Good afternoon, Your Honors. For Plaintiffs Appellants, Arun Subramanian from Sussman Godfrey, I've reserved 2 minutes for rebuttal. The district court in this case held that no reasonable juror could think that the defendant's conduct was outrageous. We would respectfully submit that that's error. The defendants in this case targeted and victimized 2 grieving parents shortly after their son had been murdered, turned them into pawns in a political game, and enlisted them in pushing a false story about their dead son. It can't be that on allegations such as these, we're not even entitled to a right to discovery, and that's certainly—
You have to convince us that this was outrageous with respect to the parents, not outrageous with respect to the son who was killed, which would support a defamation were he still alive, but the defamation case has died with him, and so you have to convince us that a separate case, which in torts does lie to the parents, it has nothing to do with whether there would be outrage to the child, and that this was what they did was outrageous to them because of their propensity, because of all of those things.
That's absolutely right. And if you look at what we've alleged in the complaint and in our briefing, this is conduct and speech that was directed at the plaintiff. So we're talking about what the defendants did as to Joel and Mary Rich. And if you look at what they did, interfering with the parents' investigation, planting an investigator who they knew was going to defy what the parents wanted, pushing the story with the investigator before the article is published, and then putting out a story that enlists the parents' investigator as the corroborating source for the fake FBI agent who doesn't exist, who pushes this false story about their son.
The principal basis for making this outrageous to them was putting somebody supposedly to work for them who was actually working for opposing, for the people who wanted to make this story, and to treat people who were worried about the death of their child in that situation by putting their Wheeler to cheat. That was the thing that made it especially outrageous.
I think that that's right, and it's also the only reason that this story can ever be published, because if you remember, there were some fringe stories about Seth Rich and this whole WikiLeaks connection before, but what the defendants needed was a link from inside the family to corroborate and kind of give life to this story. And so this was all connected, but you're absolutely right that the initial conduct by the defendants, putting the investigator within the family and then utilizing that investigator in the story was key outrageous conduct here. And Your Honor also pointed to the propensity for vulnerability of the parents. That's a key consideration that the restatement considers in Section 46, is how vulnerable are the plaintiffs and what is the defendant's knowledge of that? So in cases like Estate of Duckett, the court looks at the fact that at the pleading stage, there isn't a developed record of what the defendants knew about the vulnerability of the parents, and that's at least one reason why discovery was warranted. And just notably, when Duckett court was discussing the allegations, it noted, when dealing with survivors of a decedent, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. And we think that that principle applies here a fortiori. The defendants point, what they say is that this is defamation in disguise for the reasons we've discussed. We don't believe that that's true. Then the defendants turn to this First Amendment argument, and we really don't think that that holds any water here. So first, on the of and concerning requirement, I would direct the court to the discussion in Holloway. Holloway goes through in detail and discusses why the of and concerning requirement that normally applies to defamation claims has no bearing in the intentional infliction context, because the two different types of injury that are being claimed, and this is what Judge Calabresi, you began with, that in a defamation case, you're pleading injury to the plaintiff's reputation. And for that reason, they have this of and concerning requirement, because speech that isn't of and concerning the plaintiff is unlikely to affect that plaintiff's reputation. That's not the claim that we're asserting
here. I have a question about the
here.
negligent supervision thing. Did you plead respondeat superior, as well as did you, in your complaint, did you say respondeat superior, that Fox was responsible for the negligence of the employees if it was in the scope of employment, and negligent supervision if it was not in the scope of employment, or if they were independent contractors? I mean, just in terms of, this is 12b-6, and so did you make that pleading? And if you did not, did you ask to amend in order to make that pleading?
We certainly didn't amend to make that pleading, and what I would say about the two different prongs that Your Honor kind of voiced is that if we're looking to the economic substance or the true substance of the relationship and not the labels, we certainly alleged in the complaint that the individual defendants were acting on behalf of Fox, and we certainly did allege that Fox had reason to know of their propensity to commit the torts in question. Indeed, in this case, we're not saying that Fox somehow became aware of this after the fact. We're saying that Fox knew of this entire scheme from the get-go.
Last case was contracts one. This case, in some ways, is torts one.
No, right.
Can I just follow up on Judge Calabresi's question on the negligent retention or supervision count directed at Fox, right? It seems that your argument is that the notice to Fox that Zimmerman and Wheeler were acting inappropriately is just based on this case, the circumstances of these articles. Typically, we see it where someone's done bad things in the past. In other cases, the employer's put on notice, you've got a problem here, you've got to watch her more carefully. Are there any allegations as to Zimmerman or Wheeler that Fox News knew that they would act inappropriately based on prior stories they had written, or was it just this situation?
It's just the situation, and this case presents a unique situation where there is evidence and allegations that Fox was aware of the propensity as to this situation, which is usually not the case in other negligent supervision or retention cases. Just to give you an example, we have at JA 182 the retention agreement of Mr. Wheeler, which isn't signed by Zimmerman, it's signed by a senior executive at Fox in December 2016, which is the same month where Mr. Butowski begins his outreach to the family.
Say that there was enough ahead of time to give Fox the knowledge that they should watch these characters carefully.
Absolutely. Even late in time in the relationship when Zimmerman is trying to get the article out, there are communications where it is very clear that Fox is in on the scheme. I mean, they understand what is going on. Zimmerman is telling other participants that the bosses at Fox want her to go with this.
Did they know, though, that there was no FBI source for the corroboration of the WikiLeaks, or that even the Washington police had not confirmed that he was leaking these emails to WikiLeaks? Is there evidence that other people above them at Fox knew that before the stories were sent out?
Well, that's precisely our point. There's no evidence in the record at all, and especially when you're talking about the defendant's knowledge, that is something that is uniquely in the possession of the defendants. That's precisely the type of discovery that we'd want to take. I do believe that there are sufficient allegations.
The complaint allows for that possibility if there weren't a 12b-6 dismissal, and that's when we'd see whether the evidence, if it isn't there, summary judgment.
Absolutely. The allegations provide a plausible basis for relief on the claim, but to answer Judge Droney, your question, we expect that there will be evidence showing that Fox was aware of the potential falsity of the article, what Ms. Zimmerman was doing in real time and probably beforehand, given JA 182, the contributor agreement from before all of this. But that's a question of evidence, and that's all we're asking for here, is the ability to move forward with this case and discover the full scope of the defendant's scheme.
Thank you. You've got a couple of minutes reserved. Why don't we hear from Mr. Terry?
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, Joe Terry for Fox News. The claims asserted by the Riches are unprecedented in two respects. First, the Riches seek to recover damages for the emotional injury that they suffered as a result of the defamation of their son. No case cited by either party, or which we are aware, has ever allowed the family of a deceased to recover for injuries that they suffered arising from the defamation of a relative. That is true whether the claims
Now,
are...
wait a sec. Let's just separate a few things. First, let's assume that the son is in a coma but is still alive, and a defamation suit is brought. Are the allegations here sufficient so that they would go forward in the face of your First Amendment arguments? In a defamation suit, all of these things here, would they be enough so that they would go forward? Because I would suggest that they do, and if that is so, then all the First Amendment stuff in your brief is a waste of time, because the same thing applies whether you have the independent intentional infliction of emotional distress. Then the question is, does New York allow an independent infliction of emotional distress to some parties, even though a defamation suit no longer lies because the subject of defamation has died, and that ended? And that only, as far as I can read the cases, allows if there is outrageous conduct with respect to the other parties. It's got nothing to do with whether the defamation of the child is there. It's whether there is outrageous conduct with respect to the parents. So the question is there? I mean, that's what the issue is. And by the way, the court below ruled for you on the ground that there wasn't.
That is a multi-layered question, Judge Calabresi. So let me take it from the end. The question of whether or not, as a matter of common law, the Riches could assert a tort depends on whether or not there was outrageous conduct directed at them.
At them?
At them, intentionally directed at them. So the conduct has to be measured in light of the incredibly high standards for outrageousness under New York law, keeping in mind it is a disfavored tort, a highly disfavored tort, for which the New York Court of Appeals has never found a set of facts to be sufficient, and it must be intentionally directed at them.
It hasn't to do with so much about whether you are calling the son a traitor. That would be defamation of him, but it has to do with whether you are using somebody whom the parents thought was working for them in order to do something of this sort. That's the claim of intentional infliction of emotional distress. And that's what we're focusing on. We're not the fact that they then publish something that the child was a traitor. The important thing there is that they're doing it with a source who was put in. And it's that we got to look to for outrage. Am I right?
Well, Your Honor, I would take issue with that in this respect. Every injury that they articulate in their complaint stems from the publication of disparaging comments about their son. And let me be specific about what they say. They allege the scurrilous allegations, quote, about their son caused emotional harm.
But what about this, though? The Wheeler contract was with them. And the whole idea, allegedly, is that Fox News orchestrated the Wheeler contract so it would appear as if Wheeler was working for the parents, so he would be more credible if he came up with information about the leaks. Why wasn't the Wheeler contract directed at the parents?
First of all, there's no allegation that Fox had anything to do
All right,
with
so
the
forget
Wheeler
about
contract.
Fox. Zimmerman, Butowski, orchestrated, there's allegations they orchestrated with Wheeler, the Wheeler contract. Of course, Zimmerman works for Fox, but put that aside for now. But why wasn't the Wheeler contract directed at the parents? The whole idea was to make it look like the investigator for the parents, if he concluded that Seth had leaked the emails, were with him on this.
So two answers. First of all, if you take a look at the allegations of their complaint about the formation of that contract, it says that Butowski and Wheeler conspired to create this sham agreement, not that Zimmerman or Fox were engaged in that. So there are no allegations specific to Fox about the creation of that contract. Second, the question is not whether...
Isn't the point that they are saying, you said that our guy, the guy we hired, came out with the conclusion that our son was a traitor. And that is what is inflicting tremendous distress on us, and we were demonstrated propensity for it, which in New York is important. Why isn't that the question? The fact of a child being a traitor is only relevant because of the link to saying you are using us to say that our child is a traitor. And we got to say whether that is outrageous enough under very, very strict standards for outrage in New York.
Yes, Your Honor. I think the distinction is that they specifically allege what the cause of their injury was in great detail in the complaint. And that is that they are distraught because their son's good name and reputation have been irreparably harmed. When they articulate their injuries with any specificity, it all flows from his reputation.
Isn't the question of what then made them distraught a question of damages? That is, to the extent that if you got by this and you got by summary judgment and the facts are in fact as we have to take them as given, you then would have the question for the jury, ladies and gentlemen of the jury, you may not grant damages for any suffering that they felt simply because the child seemed to be a traitor, but you may recover for anything that goes to their suffering because they were the ones who were calling the child the traitor. And that's just a question of how you charge the jury, and then the jury decides which of these damages. But haven't they alleged both?
No, Your Honor, and it's actually more than that. The question of whether or not a claim is a defamation claim or something else matters not just for First Amendment purposes, but for the New York common law rule that if something falls within the ambit of defamation, it cannot be restyled as intentional infliction. And defamation is defined by the nature of the damage. A defamation claim is a claim based on damage to reputation or psychological harm, whether it is to you or to others. So it is the nature of the injury that makes this a defamation claim.
It has to be an injury to them, yes. It cannot be an injury to, because defamation dies with somebody. So let's go back to my hypothetical where the person is alive. You could have, but in a coma and can't speak, you could have two suits. And each of them would proceed, and they would have their own terms, and they each could go forward. But it doesn't mean that because there is that defamation suit, the suit for their damages, if it is outrageous enough, cannot go forward.
There would have to be two different types of suits because the law is quite clear that family members cannot recover for damages, direct or derivative, based on reputation.
It cannot be for defamation to the child. We're all in agreement.
That's true. And so the question of whether or not there is outrageous conduct here, it has to stand alone, not on the publication, but on the pre-publication conduct. So the question is whether that conduct, setting aside what was said in the publication, were the acts allegedly undertaken by Fox outrageous? Because you can't combine the two.
And the question is whether that is sufficiently pleaded to get by 12b-6. Because that's where we are. So that it isn't even a question of whether they have now enough evidence, but whether they have pled enough that is plausible so that a jury would be allowed to find insufficient evidence of that. Am I right or am I wrong?
Well, Your Honor, what the courts have said is that whether the conduct alleged may reasonably be regarded as so extreme and outrageous to permit recovery is a matter for the court to determine in the first instance. And in almost every case we cite, the cases are thrown out on motions to dismiss because the court makes the determination the conduct is not sufficiently outrageous. And if you compare conduct that New York courts have found to not be sufficiently outrageous to the conduct alleged here, it's quite clear it's insufficient. Take, for example, the Doe versus ABC case, where reporters were alleged to have lied to rape victims about whether their identities would be obscured on a broadcast. Lied multiple times, their identities were not obscured, and they sued for emotional distress. The court said that's insufficient. Other stories where victims of sexual violence were outed against their consent, against promises that they would not be outed, and that was not sufficient. We know that false statements from reporters to sources are not sufficient to give rise to such a claim, nor are false statements in a publication sufficient to give rise to such a claim. And what New York courts have said are not only are these torts highly disfavored, but they must intend to cause the harm. And so the question is not simply whether or not there was interaction with the Riches and there was activity directed towards them, but was it done with an intention to cause them harm?
Reckless is enough for intent, isn't it? I mean, reckless behavior in New York for intentional infliction of emotional harm, if it is reckless enough, you don't have to show that I intend to harm you if it is reckless enough that this will happen.
But their conduct must be directed at the Riches with that in mind.
Yes, always directed
So
to
then
them.
the question is whether or not the conduct allegedly undertaken by Fox pre-publication that was directed at the Riches was in reckless disregard of the chances that it would be conduct that would be so beyond the bounds of conduct in a civilized society that it should be considered outrageous, particularly when you consider that New York courts have said that that tort should not be found unless there is a pattern and a campaign of deliberate and malicious harassment. It clearly does not reach that standard. New York courts have said that repeated times. They've rejected claims because there was no deliberate and malicious campaign of harassment. There are no allegations of pre-publication conduct that are deliberate and malicious, let alone a campaign of harassment. The facts simply don't fit this tort. The same is also true for the tortious interference claim, if I may address that briefly.
Do you want to take another minute?
Yes, Your Honor,
Go
thank
ahead.
you. No court has ever applied that commercial tort to find that a reporter has committed tortious interference by getting a source to reveal confidential information in violation of a confidentiality agreement.
If we're in doubt as to this situation, which is a quite unusual one, quite unusual, should we certify the case to the New York Court of Appeals?
Well, Your Honor, I think there are several reasons.
I mean, it's an odd situation because the New York Court of Appeals has said what the standard is, so that we don't really have an issue of law, but we have a very unusual case. Is it appropriate to say to New York, what do you want to do with an unusual case?
I think this is not such an unusual case because there are lots of cases where relatives try to bring defamation claims or claims for their emotional injuries based on what happened to a relative, and those are uniformly denied. There are lots of cases where people allege that they were deceived by reporters, sometimes in ways that we would all think is relatively unpleasant, like lying to rape victims. The courts have uniformly found that that conduct is not sufficient to give rise to such a claim. And I think that when you layer on the fact that there are significant First Amendment concerns raised by this, there are sufficient reasons to uphold the district court's decision without certifying any question to New York. I think if you certified the question to New York, they would say what they have said before. This is an extremely disfavored tort, and it should not be found in the absence of a campaign of deliberate and malicious harassment. Thank you.
Thank you, Mr. Terry. Mr. Subramanian, you have another minute. 2 minutes. 2 minutes, I'm sorry.
Thank you, Your Honor. Counsel said that there was no allegation in this complaint of deliberate or malicious conduct that preceded the article. I just don't think that that can be fairly reconciled with the allegations of this complaint. This complaint is all about the defendant's actions before the articles were published to rope the parents in as a vouching, corroborating source for what they wanted to say in the article. And that's the injury, and that was to the parents and not to Mr. Rich. In terms of the cases, Mr. Terry mentioned that the Court of Appeals has held these claims to an exacting standard, and we're not trying to run away from that standard. We accept that and we embrace that, but this is, as the court has pointed out, an unusual case. It's unusual because of the severity of the actions that the defendants have taken. And New York courts have sustained claims that we would submit are of lesser severity than what we're talking about here. Cases like Mulberry, Esposito-Hilter, the Duckett case, which is a non-New York case but applies the same standard, and also Holloway, which was a pure speech case and involved no preceding conduct. And if you look, Your Honors, even at the illustrations that are in the restatement, you'll see that some
Counsel,
of those illustrations.
You will agree that the New York courts are especially careful not to let intentional infliction of emotional stress be a way around the failure of a defamation case because somebody has died. That is, the New York courts don't want, in the ordinary case, to have the suit that has abated be brought back in another way. That doesn't mean that you can't have it separate, but that you have to be very careful.
Absolutely, and that's why I think the discussion that we had during our opening argument and also on the opposition argument about the distinctions between the claim we're advancing here and defamation are important. We're not trying to assert a defamation claim that has to do with damage to the plaintiff's reputation. We're talking about the outrageous conduct that was levied against the Riches. In terms of what the allegations of injury are, I know my time is running short, but I don't think you can read the complaint and not understand that what's being claimed as the injury is the parents being brought in to vouch for the substance of the article. You could just look at paragraph 4 of the complaint. Defendants intentionally made it appear that Joel and Mary were involved in and confirmed the substance of this smear campaign. That's from the beginning of the complaint. If Your Honor, no further questions, thank you very much.
Thank you both. We'll reserve decision. That's our final argument, so we'll ask the clerk.
If I may say so, very well argued by both sides. Thank you.
I'll ask the clerk to adjourn court at this time.
Court stands adjourned.